Good morning. Today is May 4th, 2023. It's approximately 9:30 in the morning. This hearing concerns application Z0088-23-SL. It is known as the application for the Chloe Rose subdivision, a planned unit development for 15 lots. My name is Carl Cox. I'm a private attorney. I am the Clackamas County Land Use Hearings Officer. And I have a couple of statements to make concerning this hearing. First, I've not received any ex parte contact in this matter, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I have considered issues of bias and conflict of interest and have determined that I do not have any bias or conflict of interest in this matter. The county is making a record. That record is available through the county. The exhibits and materials that will be considered at this hearing were posted on the county's website. I had an opportunity prior to this hearing to download those exhibits, including the county's staff report and the application in this matter and some background information on this, and review them. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. Prior to the end or prior to the closing the record in this matter, I will make an offer for the parties and any member of the audience to request that the record stay open for submission of additional evidence, arguments, or testimony. At this time, I will ask the county to provide an explanation concerning participation in this hearing via the Zoom platform.
Thank you. The public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar. It's the top or bottom, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you've provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email written testimony to bblessing@clackamas.us or mail it to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by the following: by email to the staff contact for the application or by entering it in the Zoom chat function during the hearing. Thank you.
Thank you. The order of proceedings will be that I'll ask the county to begin by presenting the county staff report and information, evidence, testimony that the county wishes me to consider in making a determination in this matter. I will then provide the applicant an opportunity to similarly submit information, testimony, evidence that the applicant wants me to consider. Then I will ask if there are members of the audience or members of the public who are present this morning who also want to similarly provide evidence, arguments, or testimony for me to consider in making a decision concerning this application. Please proceed.
Thank you. Okay, my name is Ben Blessing. I'm a senior planner with Clackamas County Planning and Zoning Division. The staff report to the hearings officer. This application is file Z0088-23-SL. It's being called Chloe Rose. It's a major subdivision. That's 15 lots. It's also a planned unit development, meaning they will have flexibility in the lot sizes and siting standards. A vicinity map to get you oriented, the subject property highlighted. You have the Oatfield Ridge, and then it would be I guess the eastern slopes of it, and the development, which you'll see on subsequent slides, is on the upland portions thereof and flat portions. So just to describe the subdivision, it's detailed in the staff report, but this property was authorized in 2018 for a subdivision, and there was also a zone change and a conditional use permit. But as far as the subdivision was concerned, that time frame to finalize and record the plat was expired, so hence the applicant had to submit a new subdivision here. As you can see, this is a 22 aerial. I'm sorry, I'm terribly sorry. It's not summer 23 because that wouldn't be possible. It's last year, summer 22. So just note that this was taken last year. It's showing this infrastructure being built and so forth. So as you can see, that much of the site is developed with the infrastructure that's needed, and staff visited the site. The completion is considerable. The storm facilities appear to be in, and so forth. I'm just mentioning this to give you some context of the application. It's still a new subdivision, subject to all the standards in effect when the application was submitted. A site plan of the project. As you can see, you have a private road and you have 15 lots. You have a protected open space tract, as you can see here under tract A and tract C, which just protects a small creek. The West Water Environmental Services has reviewed the buffer, and that was done some years ago. So the buffer is the buffer alignment, as you can see on the lots, is okayed by the service, the service provider for stormwater and surface water management. The lots are essentially just kind of flexible small lots on the top of the hill, and you have the development at the back, and then behind those lots, essentially to the northeast, is where you have more open space. It's all being preserved, treed, and that'll continue to be preserved in perpetuity. And the road, Chloe Rose Way, is a private road again that I didn't put the extent of the public road, but it's a short run. Once it enters the McNary Road, it's a short stub here, and then it enters the public road system. We do have Ken Kent here, which is great. He's with our engineering division, and he can speak to some specific roadway questions if those arise. So that's good news. Just a couple of quick highlights again. It's a 15-lot subdivision and planned unit development. There again, planned unit developments are appropriate in this matter. in this kind of a development because it preserves the open spaces, which the applicant has done. It provides flexibility in the lot sizes, so you don't have the typical urban load single family residential setbacks in the R10 district, and there's some flexibility with siting the homes with a little more intense use of the building area to preserve as much of the natural features as possible. Again, much of the infrastructure is involved, as noted, and as shown on the prior slide. It's complete. This authorization, they will be able to continue with finalizing any of the conditions of approval and recording the plat. Proposal still complies with ZDO. Service districts will continue to require their conditions to be met. Service district conditions and comments are made part of the record, and they're noted in the staff decision. Recommendations from Wes and Oak Lodge Water, who are the Wes being the sewer and stormwater provider, Oak Lodge being the drinking water provider, are noted in the conditions. So those will also need to be met, as I just said. So the recommendation to the hearings officer is approval of the 15 lot subdivision with conditions of approval noted therein in the staff report. So that concludes my presentation. Thanks.
I do have a couple of questions, and the applicant could answer if you don't have an answer for it. I saw some references to, I thought, 2 duplexes. Is that correct? And so the 15 lots, but we're talking about 17 residences, 17 dwellings.
Yes, and maybe Garrett and Matt can attest to this, but the original land use approval in 2018 authorized the 2 duplex lots because they were large enough. But I don't, and correct me if I'm wrong in your submittal, Garrett, I don't think it shouldn't matter now because the conditional use requirements for duplexes have been essentially subsumed. I'm not sure if that's the right term, but we now have middle housing. So there's no requirement for duplexes. So I don't know, I can't recall if you actually noted on your submittal that you'll be doing duplexes, but it's a primary use now with middle housing under section 845. So it just like any lot of record out there, it could be a duplex on any lot of record. So I don't know if that helps, but maybe the applicant can help, supplement that.
Sure. Mr. Cox, would you like me to chime in?
Yes, please.
So I don't have much to add to what Ben said. I mean, at this point, the middle housing allowances for duplexes are by right. I do think that there's going to be a couple of duplexes going in there. I don't know that there's going to be any more than were originally proposed with the conditional use. But Matt, if you can hear us, maybe chime in here. I know of just a couple of duplex permits that we're looking at, which would have been consistent with the two conditional uses for those duplexes that were originally proposed. We did not address that. It's really a development issue at this point. The main thing we're trying to do is just reauthorize the plat so we can get it recorded.
Okay. And I have a question then for Mr. Kent. And thank you for being present this morning, sir. Does increasing the number of single-family residences in this make any difference to your analysis of the engineering and traffic?
It does not in terms of the road system, at least internal road requirements and the widths. The number of lots, if they were to, in fact, construct duplexes on all the lots, the road system that they're developing would be the same. I think the only thing that can come up is traffic impacts. But looking at the county hasn't adopted any specific policy on assuming the highest development with middle housing. But even if there were duplexes on each lot, based on the slightly lower traffic impact or trip generation for a duplex versus a single family house, it still would approximately be equivalent to 20 peak hour trips, right on that verge of whether a traffic study would be required. But given the existing road network, staff feels there wouldn't be any capacity issues with the surrounding intersections and roadways serving this site.
Even if they're all duplexes, your opinion is it still falls within your the conditions of approval and your recommendation?
Yes.
Okay. Thank you, sir. I have my question answered. I didn't think it was very clear exactly where it was going with the Middle Housing Act there, and so I wanted to make sure that I understood. All right, did the applicant have anything more that the applicant wants me to consider in making a decision here?
Mr. Cox, nothing terribly more than what you heard from Mr. Blessing and Mr. Kent. I just want to kind of give you the sort of backstory, and maybe that helps make sense of why we're doing this. This was a project that was originally done by another developer. My client took ownership of it, and I think in that transition, a deadline was not calendared or something to that effect. And we're at a point now where pretty much everything that we need to do to record the plat has been done. The main thing that we need to do is just essentially reauthorize this. As Ben mentioned, everything that has been installed is consistent with the public works permit requirements. And for those of you, I know Mr. Cox probably knows this, but for those of you in the audience who might be unaware, when you develop subdivisions, of course, you have conditions of approval that include building your roads and putting your water and sewer lines in before you can record the plat. And that's why you'll see on the aerial the roads in, the stormwater facility being constructed, the pipes are in, and all that stuff actually has to be done prior to the plat being recorded. And when the plat is recorded, that's when you can then sell the lots and build homes and so forth. So it's a pretty simple procedure that we're doing here. Luckily, we got in before there are any changes in the code. So all the code provisions that applied in 2018 apply now. The only change is the authorization, as you mentioned, for middle housing. That does not affect the plat. The lots are what they are. It's a small project from a traffic standpoint, which makes things a little easier. So what we would like to do is just get the plat reauthorized so we can record it and finish the project. So we've looked at the conditions of approval. They're exactly the same as those that were issued in 2018. So we're comfortable with all of those. And we hope that the hearings officer approves the project based on the staff report and recommended conditions of approval.
And thank you for answering my next question, which is if you'd had an opportunity to review the conditions of approval and had any objections to any of them.
No, they're all the same. And we actually, if you look at the conditions, there's actually a statement on, at least from the county's public works side, that, the permit has been issued and all the construction that is done thereunder is consistent with the county standards. And we have an email from Water Environment Services, and these are the two big buckets of conditions that we usually get. And Wes says they're the same conditions as before and everything looks fine. So we're 100% comfortable with that.
Thank you, sir. Is there any member of the audience who has a statement or evidence to submit for me to consider in making a decision? Use the raise hand feature. Let's give it a minute. No one? Okay. Does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Use the raise hand feature. Does the applicant wish to waive the period for final written argument?
Yes, the applicant waives that.
Then the record will close at 4 p.m. today. I'll look for Mr. Blessing for you to submit your PowerPoint, any other documentation that we discussed today at the hearing. I'd like to receive that as well. I don't recall exactly anything specific, but Thank you all. I intend to review all of the materials submitted and issue a written decision approving the application. Thank you. With that, I'll close the hearing, looking to receive the additional information we just discussed by 4 p.m. today.
Thank you, Mr. Cox.